So, as Katie mentioned, I work at Horwood, Berk here in Chicago. I spend a good amount of my practice in the venture capital area, representing both companies seeking and obtaining growth capital to, become the next level up or whoever you want to pick, and then also professional investors who are investing in those sorts of companies. I first got involved in the practice about 20 years ago when the guy I went to college with became a venture capitalist, and I started doing work for him. And as you know, in your practice, one thing leads to another, and I get to know more people in the community, and from working with investors principally to working with both investors and companies. I started my career at Catton, left there in the early 90s, worked at a very small firm that did venture mostly. Worked at a Catton spinoff for a while, had my own firm with a partner for 5 years, and I've been at Horwood, Berk for 12 years now. We are very much a middle market law firm, do all sorts of corporate transaction work, well beyond venture, including bank finance work, general corporate work, specialty finance work, M&A. I do a little of most of those things, but I spend a lot of time in venture. How the heck did I get here? Speaking to a Kent group, I had the good fortune to work with Heather Harper, who chatted with me briefly on the way in on a transaction this summer. And I said to Heather, gee, I think you got great things happening at Kent. How can I be helpful? And came over and did a presentation to a student group, I think in November, on much of the same stuff that we're going to talk about today. And then Heather introduced me to Katie and said, well, gee, maybe we could put together CLE around a lot of the same stuff. So here we are. Thank you all for coming. I've given these sorts of presentations to rooms of various sizes, and it's always nice when the seats are filled. So thank you. So we're going to talk about a variety of things today. As Katie already alluded to, and I'm going to walk around a little bit. I'll probably make the camera person crazy, sorry. I'm going to walk around a little bit while I'm doing the presentation. But a lot of the back part of the presentation, maybe the second 2/3 or so, is going to review some form documents, which are not contracts, but rather term sheets, which sort of drive in summary fashion the things that are important business terms when you go to document a venture capital investment. Those things are, well, the principal document we'll look at, which you'll all have in front of you shortly, although we're not there yet and it's not on the screen yet, is a term sheet prepared by a bunch of lawyers under the auspices of something called the National Venture Capital Association, which is a trade organization, lobbying organization, principally for the venture capital and private equity industry. And before I forget to mention it, if you go to nbc.org, which I mentioned a couple times in my materials, and you click on the tab called Resources, and then you go among the legal documents, you will find not only the term sheet that we're going to talk about today, but also a bunch of what have sort of become standard, state-of-the-art agreements that people use to document venture capital financings of a certain size. And they're wonderful resources if you haven't spent a lot of time in the area and then get the opportunity to, because they are annotated, as is the term sheet, and also have alternative provisions, and I think do an outstanding job of sort of explaining what's going on underneath the hood. Those documents were prepared by lawyers, self-appointed experts perhaps, but people who spend a lot of time in the practice area and decided that the documents could use some standardization, both for the benefit of lawyers and also their clients, to try to manage legal costs, remove the number of issues that lawyers were fighting about as they reviewed one another's forms and tried to get familiar with one another's forms. So we work with them frequently in the area, and they've been, I think, a real benefit to the practice. Before we start talking about that stuff, we're going to go through a series of PowerPoint slides, which I've entitled, What's Behind the Waterfall? Waterfall is a term of art in the venture capital practice, and like any other practice, I'm sure this is true of you guys, whatever it is that you do on a regular basis, you develop your acronyms and your jargon, and you use it without necessarily thinking about it. So waterfall is the term that lawyers and business people in the area use to describe how money is distributed when a company is sold or otherwise liquidates, and now it's time figure out who gets the cash. So what's behind the waterfall alludes to what's really going on in these documents and what's important about how these things are structured, and particularly for companies who might not have a lot of exposure to the area and might not have a high level of sophistication, where are the bodies buried in terms of negotiating with a prospective venture capitalist, what should you worry about, what should you not worry about. So that's the context of what we're going to start with. Okay, so let's go to the hypothetical transaction slide. So the hypothetical that we're going to talk about in this context, we have a new company. Founders of that company have been putting blood, sweat, and tears in for some amount of time to try to grow this business. They have invested blood, sweat, and tears, but not in cash. And now they're finally at the point where they think to really have this business take off, grow, we need outside money. There's an investor who they have convinced of the fact that this company has promise, and the investor is willing to put $1 million into the business. And the business deal is that the investor is going to own 25% of the company. So the sort of subtitle of this presentation is in the third point on the slide here, which is how much is 25%? Seems like a pretty straightforward question. But as we'll explore in these slides, in the context of the way venture capital transactions are structured, not always as straightforward as you might think. I don't like asking how many people have ever heard the concept of pre-money valuation, but I'm going to start by talking about pre-money valuation. In order to do an economic analysis of the sort of a deal that an investor is offering the company, you have to be able to understand what the pre-money and ultimately post-money valuation of the company is. And those are another couple of our jargon terms. So in order to compute pre- and post-money valuation, which really is just what valuation of the company is implicit in the economic transaction between the founders of the company and the investor, I need to know two numbers, which we put on our first slide, which is how much money was invested. In our hypothetical, that's $1 million. And how much of the company did that money buy? And in our hypothetical, that's 25%. So the economic rationale for this is, well, if an investor is willing to put $1 million in a company and own 25%, that must mean, assuming economically rational actors, that that company was worth $3 million before the investor's $1 million went into it. Because the $1 million is going into the company, right? It's not going to the existing owners. So the company's worth $1 million more post-investment than it was pre-investment. An economically rational actor would say, well, if I own 25% of it for $1 million, that must mean it was worth $3 million before I put in my money. So in our hypothetical transaction, the pre-money valuation was $3 million. The post-money valuation is $4 million. And in my last bullet on this slide, there's a very straightforward fraction by which you get to those numbers. I take the amount of money that was put in, and divide it by the percentage of the company that was purchased, 0.25% here, and I get my post-money value. So far, so good? Questions? Okay. If I'm not making sense at any point, it might be me, it might not be you, so don't hesitate to ask. So another thing that affects pre-money valuation and that we deal with commonly in this transaction is the existence of an option pool. Everybody assumes in a company like this, they're going to have to go out, they're going to have to hire a whole bunch of people. They're probably not going to be able to pay them market salaries because they're strapped for cash. So how do you induce someone, a computer programmer who's got all sorts of job opportunities, to join this business if you can't pay them a market salary? And the answer is, well, let's give them some equity incentives. Another way of looking at what we're just going to talk about now is, well, where do those equity incentives come from and who bears the economic burden? So in a typical venture capital transaction, an investor would say, before I write you my $1 million check, I want you to put an option pool, as we call it, a bunch of shares not yet issued but to be issued in the future, on your capitalization table. So we're going to pretend that those shares are issued and outstanding before we do the math of figuring out how many shares my $1 million buys. So the first little box here shows if I put an option pool on pre-investment and I now reduce my percentages to shares, the founders are going to own 600,000 shares. The investor is going to own 250,000 shares. That's the 25% of the company that the investor was buying. And the option pool is hypothetical number of shares to be issued in the future to bring on all these talented people. That's representing 15% of the total capitalization of the company after the investor buys its 25%. Why is that important to the investor? Well, if we wait until after the investor writes the investor's check and then create that 15% option pool for future hires, the investor, in our second box, actually is suffering dilution from that option pool and doesn't own 25%, but owns 21.2%. So our first illustration of a situation where 25% isn't necessarily 25%. The flip side of that is if you look at the issued and outstanding shares that are sold where the hypothetical option pool is put on the cap table first, that's our first box, the investor actually owns 250,000 of 850,000 issued and outstanding shares, which is more than 25%. All these things are commonly addressed and commonly negotiated in the context of one of these transactions. And a 15% option pool, you're right there. The 15% option pool would be a relatively typical size of pool to create in a first round of financing. Yes, please.
First and second are the same.
Yeah.
The numbers, so I'm not sure what.
Yeah.
Well, that's a problem, isn't it?
Yeah.
They're not the same on my copy. So let me tell you what they should say. And thank you so much. So here's what they should say. So if you have paper in front of you, you can change the paper. What they should say is that in that second box, the founders would have 750,000 shares rather than 600. The investor would still have 250 because that's. I'm giving this to Katie so she knows that I'm not crazy. Something got transmogrified in here. So that would be 750 and 250. So now you have 25% of the issued and outstanding shares owned by the investor. And then you layer a pool on. So that number gets a little funky. That number becomes 177,000. Because to get to 15%, we're now putting 177,000 or 1,177,000. Okay. And what that then means is that if that option pool winds up being fully utilized in the future, the investor didn't get 25% in both the first and second boxes. The investor got 21.2%. So there's an arm wrestling match in the course of the negotiations over how big that pool is going to be for purposes of calculating pre- and post-money valuation. The investor wants it to be as large as possible, so if the company continues to grow and has to issue a whole bunch of options, the investor isn't taking dilution of an ownership percentage from the issuance of those options. The founders of the company want that number to be smaller, because then if it turns out that the company needs more options later and has to, as we say in the practice, reload the option pool, at that point, those additional shares that go into the option pool will be diluting everyone, including the investor group. So this is an argument that really relates in a direct way to pre- and post-money valuation and how much the company is really worth. All right, well, let's go to the next slide and see what it says. Okay, we're doing good. So remember that I said that these options are going to be hypothetically issued, but they may never be issued. It's possible the company could be the subject of an early sale transaction. They make a lot of progress, and in our hypothetical here, 50,000 of the options that were placed on that option pool, pretending for valuation purposes that those shares have been issued, in fact, don't get issued at the end of the day. Well, that has an economic impact to both parties. Because if 50,000 of those options are never issued, excuse me, I've got it backwards. If 100,000 of the options are never issued, and 50,000 are, the only amount of shares that actually take up some of the proceeds of the sale transaction are the 50,000 options that were actually issued. So now, when we look at the way the money gets distributed, we're not looking at 1 million shares, we're looking at 900,000 shares that are taking the distribution proceeds. So in these hypothetical facts that I put in the slide, if I sell the business for $10 million, the founders are going to get $6.67 million, the investors are going to get $2.78 million, the option holders are going to get $555,000. And if you take the percentage of that $10 million that the investors got, it wasn't 25%. It was actually 27.8%. So the investors got more than 25% of the sale proceeds by reason of the fact that they negotiated to put an option pool on the company's cap table before they wrote their check, and then there was a liquidity event with respect to the company before all of those options were issued. So those 100,000 options were not actually dilutive to anybody. And the founders, who thought they were going to get 75% of the proceeds, are in fact getting 2/3 of the proceeds. Let me just take a pause and a breath there.
Can you repeat that last part in terms of who gets what? I'm sorry, I didn't catch it.
Absolutely no problem. So think of it this way. When I set up my original hypothetical, we were working on a base of 1 million shares, right? About 150,000 of those shares were not yet issued, right? So I thought my denominator was going to be 1 million shares. By the time I get to actually sell this business, the business grew so quickly, they didn't need to issue those 150,000 shares that we had placed on the cap table, hypothetically, when the investor wrote the check. So when we go to compute sort of the fraction, the numerator and the denominator of who gets what percentage of the proceeds when the liquidity event happens, that denominator, hypothetically, on my original cap table was 1 million shares. 600 for the founders, 250 for the investors, 150,000 for the option pool. Well, it turned out that that was 50,000, not 150,000. So now my denominator is 900,000 shares. Am I okay? So now I'm taking that $10 million. Had all those options been issued, I'd take that $10 million. It would be 1 million shares, right? Everybody would get $10 a share, and we'd all go on our merry way. But here, I'm not doing that. I can't do the math in my head, I think, but maybe I can. So I'm going to take that $10 million and I'm going to divide it by a numerator of 900,000 shares, because the 100,000 hypothetical shares that were in the option pool never got issued, right? So now everybody's going to get $11.11 a share instead of $10 a share. That means that the investor gets more money, right? More than a total of 25% of the proceeds. So the founders thought their investor was getting 25%. Right? That was the deal they negotiated. But because of the existence of the option pool, the investors actually got more. Something approaching 28% of the total. Did I do okay?
Yes.
Okay.
Does that happen frequently?
Yes.
I mean, is that a pretty characteristic?
Yeah.
Thank you.
Yeah. I mean, it happens frequently in the context of an early liquidity event. You know, it's also not infrequent that for companies that, you know, really grow, they wind up creating new option pools all the time. And we'll talk about that a little bit later. The real economic issue at the beginning is how big is the pool? Because that ultimately affects who's going to suffer dilution down the road.
Thank you.
Great, thank you for asking. Like I said, please don't hesitate.
I have a question.
Yeah.
Could you talk a little bit about the taxing issues related to options versus receiving stock as an employee?
Can I say that?
Thank you.
I'm sorry?
Yeah, tax issues.
Yeah. I mean, they're all.
I'm sorry, you did not say that. I'm asking.
No, can I save that?
Oh, sure, of course.
Because I'm sort of deeply middle of this now, and tax issues are complicated, and it'll take 5-10 minutes for us to talk about it, and I just don't want to go there right now. Yeah?
How often is it negotiated that option pool is pre-investment? I mean, the business owner would want that, so it's not diluted. Do investors allow that, or do they really push to have it posted?
They really push to have it posted.
Does it ever happen?
Some of them. I mean, if you're dealing with investors with a certain level of sophistication, I don't know, Heather might have a view on this, but you know, if you were dealing with, oh, it's a friends and family, they're really close to me, you know, they didn't invest in anything I did because it's me. But for anybody with any level of sophistication, your debate is not going to be over, is there going to be an option pool on the cap table before the check is written, but how big is it going to be? And for founders who have a level of sophistication, you will see some of these numbers come out in really sort of funky places. I'm working on one right now where the option pool is 11.7%. Why? It's what they negotiated, okay? I mean, there's no other way to explain it. But that math is even more complicated than the math that's on these slides, so I tried to keep the math relatively simple. So the conversation we've had to this point has been working under the assumption that everybody owns the same kind of stock, common stock. But as you may know or may have heard, investors, most often, and I'm talking about investors with a certain level of sophistication, professional investors, so-called super angels, angel groups that work in a sophisticated way, they're going to say, no, we want preferred stock. We don't want common stock. And the kind of preferred stock we want is convertible preferred stock. So we're going to talk a little bit about why economically investors want convertible preferred stock as opposed to buying common stock. So now we have a different set of assumptions, but they'll tie back a little bit to some of the assumptions we already made. So again, our founders have paid nothing for their stock. Sweat equity. Investors paying $1 million for 25% of the company, familiar to us by this point. Company gets sold, but instead of that happy exit that I was illustrating a minute ago, where they sold the company for $10 million, here they're selling the company for $2 million. Not a happy situation for anybody, not what they all thought they were getting into, but at least there's something to buy that company. So let's pretend that the investor didn't purchase preferred stock. What would happen? Well, the investor owns 25%, right? Anywhere, really. So 25% of $2 million is $500,000. The investor gets $500,000, and the investor lost $500,000. And the investor's going, well, gee, that wasn't a very happy experience for me. The founders, meanwhile, own 75% of the company. So they get $1.5 million. Now, we don't know how long they were working on it. We don't know how long they worked without getting a salary. I'm not saying that this is an event that's going to cause them to go, buy the island in the Atlantic and move there. But they did make $1.5 million. So the investors go, well, what just happened here? These guys I invested in, they got $1.5 million, and I lost $500,000. That doesn't seem right to me, or certainly not something that I like or that I want to incentivize, right? Because I want my founders to work hard and make me a big multiple on $1 million. So that is addressed by investors through the issuance of convertible preferred stock. What is convertible preferred stock? It's stock that can be converted at the option of the holder into the 25% in our hypothetical facts of the common equity that we've been talking about. That gives the investor the best of both worlds. They have downside protection because in the event that the company sells for $2 million, they go, well, if I convert to common and own 25% of the common stock, I'm going to get $500,000. That doesn't seem like a very good deal to me. I would rather just take my liquidation preference in my preferred stock, and that way at least I get my money back. So in that hypothetical transaction, the investor would not convert their preferred into common. They just say, give me my $1 million liquidation preference associated with my preferred stock. However, if the company goes back to this $10 million happy exit we've been talking about, now if I'm the investor, I convert to 25% of the common, I get my 25% of 10 million, which is $2.5 million, and I walk away happy. So that's the principal business reason that investors want to use preferred stock when they invest, is it protects their downside in the event that the company has an exit at a economic level that's below the post-money valuation that was implicit in the investor's investment, $4 million in our hypothetical transaction, but still gives them the opportunity to participate in the upside if things go well. Please.
Would you see an investor also get a voting right where they had a veto on a sale? If you give them the preferred with these protections, do they lose any voting leverage to just veto a sale?
The answer to your question is yes, they would likely negotiate for that right to veto a sale, block a sale, as you call it. We'll talk about that a lot more when we get into the term sheet discussion. I'm working on a transaction right now where, again, I'm going to try to keep the story short, but the company hasn't been doing super. I represent the early investors in the deal. There's a later investor who's putting in a lot more money. My clients are fatigued. They don't want to write any more checks. The company's going to go out of business if somebody doesn't invest. So the existing investors who wrote in big checks are saying, we need you guys to convert your preferred to common if you want us to keep this company alive. So things will play out that way down the road. But normally an investor would just retain their preferred stock and keep these investments that we'll talk about in a minute. Do you have a question?
Yeah, so in your scenario, what if the company only sells for 0.5 million?
Mm-hmm.
So what happens with the convertible preferred stock?
Takes all the money.
Okay.
Yeah, up to $1 million, the founders get nothing. So if you have a situation where it's really running into the ground, the founders will wind up with money. And you know, you can debate as to the fairness of any of these things, right? But that's the way it would work. Yes, please.
So basically, it becomes that the percentage of the company before all this stuff happens would be 25% of the company in preferred stock,
Right.
held by the investor,
Right.
and 75% of the company in common stock held by the
Founders.
founders.
Yep. You got it. Anything else at this point?
Are there triggering events that would make a person have to make the election to convert that are set forth in these kinds of agreements?
Yeah, and again, we'll talk about it a little bit in the context of the term sheet. The answer to your question is yes. There's certain circumstances where you can be compelled to convert your preferred to common. Here we're just sort of keeping it simple and assuming that you had a cash liquidity event. And at that point, you got a cash liquidity event. Hey, the company's been sold. What do you want, right? We're liquidating. So then it just becomes a binary economic decision.
What happens if one of the founders leaves before the liquidity event, but if they die or something like that before the liquidity event? Do they do a fair market value at the date of death usually, or do they wait until the liquidity event and cast the estate then?
So we'll talk a little bit as we get into the term sheet about what we call founder vesting, which deals with departed founders. There are a variety of issues that can arise with departed founders. One you sort of alluded to is, well, if I depart and let's say death, I quit, right? Like your scenario. Well, what happens to my stock? Do I get to keep it all? It was sweat equity. Maybe I haven't sweated enough yet to earn all of my sweat equity. So you've got those issues, and under some circumstances you will see, even as the stock that founders could otherwise take with them, because it's vested, an option on the part of the company to buy it back at some price, which is likely to be fair market value, but often companies having some influence as to what the fair market value is. Okay, great. Thank you for the questions. I really appreciate it. I think it helps keep you guys awake. I'll be awake for the whole thing, irrespective, but definitely. So, let's go to the next slide. Things can start getting like super complicated, and you guys have asked a lot of good questions, and we've got a lot of material to try to cover in 2 hours, and I'm going to try not to get too bogged down in the math as it gets more complicated. So I'm going to give a really cursory review of these things, just so if you're working on something and they arise, you're alert to the fact that there are other ways to make life much more mathematically complicated than we've gotten into so far. But I'm going to try not to get down the rabbit hole of the complicated math. So there are two things that investors will look to do to sweeten the pot for them in terms of how they structure their convertible preferred security. And one of those things is an accruing dividend, which is here on the next slide. And an accruing dividend, I've hypothesized here, of 8% a year. Because remember, these companies are cash poor, right? So they're not Microsoft. They're not going to have a cash flow, pay their dividend every quarter. So it just sort of sits in an account off to the side, accruing, unless until we have an event that compels an economic decision, right, as to what I'm going to take. And at that point, an accruing dividend is paid. So here in the first box, I've gone back to our $2 million liquidation. And I've assumed that the investor has that $1 million investment and an 8% accruing dividend. So that's going to bounce along at the rate of $80,000 per year. So if we wait 5 years, that's $400,000. And the investor not only is going to get their $1 million back first, but they're also going to get their accruing dividend back first. So here, when we have that $2 million sale, not only is the investor going to get their $1 million back, but they're also going to get their $400,000 worth of accrued dividend back. So the investor will, in essence, get their money back plus an 8% simple annual return on it. And the founders, instead of getting $1 million left over if we just had a straightforward convertible preferred without a dividend, they'll only get $600,000. So if you see an accruing dividend, that's a signal the investor is asking for a little bit more in a liquidation scenario. Then I did another illustration with the $10 million in liquidation proceeds, which just shows that it's much less punitive. If you sell the business for a lot of money, the $400,000 is a lot less relevant than it is in the context of a transaction where the company value was down or relatively flat. Then the dream come true for the investor is participating in convertible preferred stock. And in a nutshell, rather than having to make a choice, as we described, between converting to common and losing my liquidation preference, or not converting to common and taking my liquidation preference, which is that binary decision around $4 million in a hypothetical, here the investor gets both. They not only receive their $1 million back, but then they also get 25% of whatever's left over. So in that scenario, again, I'm not going to walk through all the math, but in that scenario, the investors can do quite well. And they're not sacrificing anything for the privilege of having the liquidation preference, because they're getting both their upside and their downside protection. So convertible preferred stock is standard. Convertible preferred stock with an accruing dividend is very common here in the Midwest, much less common on the coasts. Participating preferred stock is much less common than it used to be, but still not unheard of. And what I tell my company clients is that if an investor is offering you a term sheet, investment opportunity, and there's a participating preferred stock involved, they're telling you that they think your valuation is too high. That they don't really believe what you're saying about the fact that this company's worth $3 million and I should pay $1 million to get 25% of it. Because they understand the math that I've illustrated in these boxes here, which is that if I have a participating preferred stock, I always own more than 25%. It's just a question of how much more. Because I am not only getting my 25% of the upside, but I'm also getting $1 million off the top first. So if you ever hear that phrase, or if you're ever working with anybody who gets a term sheet like that, that's what it's telling you.
Why is it less frequent on the coasts?
So I'm going to tell you what the stereotype is of Midwest venture capitalists relative to California in particular. So California venture capitalists will tell you that what they're looking for is the next Google, right? And as far as they're concerned, they either want a rocket ship or it goes bankrupt. One of the two. And if it goes bankrupt, they don't care about all this stuff we just talked about. And if it's a rocket ship, they don't care about all this stuff we just talked about. Because all of this incremental dividend participation stuff is just all around the edges. So California venture capital firms will tend to offer term sheets that are more economically straightforward. And again, I'm talking about stereotype, okay? Here in the stodgy, risk-averse Midwest, we actually worry a little bit about, well, what happens if the company isn't Google, but it does fine, and you know, we invested at a $4 million valuation and it sells for 10, okay? These things at that levels of return start making a difference in terms of what the investor walks away from, right? So, to say it in another way, you know, I tell my founder clients, if you're taking money from the coast, assume that it's this or this, right? Because they're going to push you to spend, they're going to push you to grow, and at some point you may be out of money and you may go to them and they say, you know, didn't work out, sorry. If you're taking money from a Midwest venture capitalist, they may work with you towards a sale that at least gets you something at the end of the day, even if you weren't Google. So, is that a fair answer?
I think so.
Okay.
I mean, it sounds good to me.
That's a good answer. Thank you.
Now, in New York, is it just less than is the case on the West Coast?
People will say that New York investors tend to be more affiliated with the West Coast than Chicago, in terms of how they think about things. But again, it's a stereotype. Every case is different. Every investor is different.
Okay, thank you.
No, there was a question here.
Yeah, so your founder clients, if they get a term sheet with the participating preferred stock, aside from telling them it indicates the investors think their valuation is too high, what kind of advice do you give them? If they're desperate, do you say take it? If they have other options, do you say negotiate it?
Well, the answer would be yes and yes, right? What I really tell them is go back to the investor and say, look, I know what this means. It means you don't really believe my valuation. So give me a new term sheet that takes all this fancy engineering, financial engineering stuff out. I'm just giving you a straightforward convertible preferred term sheet. Tell me what the valuation would be then. Okay? As a way to kind of call their bluff, if you will. You know, we're smarter than that. We understand that under your term sheet, 25% is more than 25%. And it's interesting because sometimes investors will go, well, this is just our standard stuff, and this is all we use. And then that's okay. I mean, then you know where you stand, right? As opposed to somebody else who might say, all right, you know, let's rework it and you know, see what we can get to. So obviously having more than one investor in the hunt is always better and useful, you know, negotiate leverage and all that. So we had a tax question, and I don't want to let it go unaddressed, and I don't want to get to 5F or 6 and have it be on and, you know, get to it. So let me talk very briefly about how options are taxed and some of the other potential alternatives. So there are two types of options broadly written. There are non-qualified stock options, which are tax disadvantageous, and then there are incentive stock options. Let's talk about the way non-qualified stock options are taxed first. Assuming a grant of a non-qualified stock option at the underlying fair market value of the stock. We're going to assume common stock for these purposes. We don't grant incentive options to employees to buy preferred. So there will be no tax upon the grant of the option. There will be tax at the time of the exercise of the option. The tax will equal the difference between the underlying exercise price of the option and the then current fair market value of the stock. So let's assume that we have options with a $1 strike price. And let's assume that at the time somebody's going to exercise those options, the company's stock is worth $3. Forget how we get there, just assume those facts. Upon exercise, the option recipient is going to recognize ordinary income equal to $2. The difference between the $1 million exercise price, excuse me, the $1 exercise price and the $3 fair market valuation. Okay? That is also because it's ordinary income. If the person is still a company employee at the time, the company actually has a withholding obligation on that tax. You can, go ahead, please. Walk freely. So life can get a little complicated at that point. Of course, if you have an option holder who doesn't have a lot of money and is not otherwise in a position to pay that tax, the option holder may go, wow, you know, this is tough on me because not only do I have to come up with $1 to exercise the option, but again, assuming a 40% tax bracket, I got to come up with 80 cents to pay the ordinary income tax associated with the underlying ordinary income gain on that spread. So that's the basic tax treatment of non-qualified stock options. I'm going to mention incentive stock options very briefly, but this is a rabbit hole that I don't want to go down. Yes, please.
Can I just clear?
Oh, I'm sorry. And we need a copy back there. Do we have any more?
Yeah. There should be some more coming later. We're having some printer issues, so I apologize.
Can you still
We'll
hear me?
have enough for everyone by the end.
Yeah.
Can you still hear me while I'm over here? Incentive stock options. I think I have an extra one. The secretary made me take one with me. Incentive stock options theoretically are great. I'm wrong, I don't know. Incentive
We
stock
do have
options.
more coming.
Incentive stock options theoretically are great things for an employee because unlike the non-qualified stock options we just described, they do not have gain associated with the exercise, and they are treated as a capital asset from the very beginning. Non-qualified stock options are only a capital asset after you exercise. So that means that in order to get long-term capital gain treatment on the underlying stock, you're going to have to hold it for a year after you buy it. The problem with incentive stock options, as life has evolved, is really twofold. The company gets a tax deduction on the exercise of a non-qualified stock option. So that's a big tax benefit for a company that's making money. The company does not get a tax deduction on the exercise of an incentive stock option. Second, the gain underlying an incentive stock option is subject to the alternative minimum tax. So the recipient, if they're pushed up in a relatively high tax bracket, winds up paying at ordinary income rates on the incentive stock option gain anyway. So incentive stock options have sort of evolved over time into the worst of both worlds because the company's not getting a deduction that it would get from the non-qualified stock option, and the recipient is paying at ordinary income rates anyway. So I've had a client or two that actually issued incentive stock options, then gotten to a point later going, oh, this is not working. Amended their stock option plans so that because incentive stock options are highly technical and it's very easy to sort of blow the requirements. So they've affirmatively and intentionally amended their plans to blow the incentive stock option to push their options back into non-qualified stock options so they can get the tax deduction, and then they sort of share the benefit of that tax deduction with the option holder. So the takeaway on all of this little aside is that options aren't always everything they're cracked up to be. We haven't talked about vesting, we haven't talked about how you sell the underlying shares and all that sort of thing. But the surprise that can happen, particularly when people with vested stock options leave a company, is they find out that under the option plan, they only have 90 days to exercise, which would be relatively typical. They have to pay the exercise price, and they might not have the money. And then after they pay the exercise price, they have to pay the tax. So in my hypothetical facts, we had somebody paying $1.80 to exercise an option worth $3, right? Because the shares are worth $3. And then what happens if the stock goes down? Well, now you've got a long-term capital loss. So you paid at ordinary income rates, and then you take a long-term capital loss. So you actually got negative tax arbitrage. So I wasn't really going to talk about that, but you asked the question. I at least wanted to deal with it a little bit.
How often does that happen? Just
I've seen
generally.
people walk away from options with six-figure underlying value because they couldn't pay the taxes.
What's the frequency though? Just,
Happens.
well,
Sometimes-
10% of the time, 5%
I
of the
can't,
time?
if I could give you an accurate answer to that question, I would.
Okay.
I probably don't have all the data, right? But I can tell you that I've seen it happen on more than one occasion. Sometimes companies really don't want to punish people, and they will make arrangements to like buy back their stock options because, you know, people have this experience. It's kind of unhappy. And if a bunch of your option recipients who have a bunch of friends at the company they're leaving from have an unhappy experience with their stock options, they might communicate that to their friends, and that's not really accomplishing what you're trying to accomplish through the issuance of these options. Your question?
If you file like an 83B for options, or is that only for stock?
No, you don't have to. Because remember I said it's not taxable upon issuance if it's issued at fair market value. So you own no property to file the election with respect to for the language. But you don't need to, so that's good. All right, let's dive into to the term sheet. So I already mentioned that this document is publicly available through NBCA.org. And this term sheet is for another hypothetical venture capital transaction. There are a bunch of agreements that are standard agreements we've worked with, and we're using these NBCA documents. The term sheet kind of maps to the agreements. Please. You don't have it, right?
We're still printing more, so I apologize. It's up on the screen to look at there, but we will have more coming.
Sorry about that. So, the first couple of pages of this term sheet that we're going to have goes through all of the stuff in a different kind of format that we just talked about in the first part of the presentation. So if you look through here, you'll see how much money we're raising, what's the price per share, what's the pre-money valuation. I'm now at the top of page 2. And you see here these blanks to be filled in. Pre-money valuation is blank. The post-money valuation is blank. It includes an employee pool representing blank percent of fully diluted capitalization, which could turn out to be 11.7% or whatever number gets negotiated between the investor or investor group and the founders. So that's where all that stuff is. The next document they're talking about here is the charter, which is another colloquial term for the certificate of incorporation, the governing document of the company, pursuant to which it's authorized to issue shares and classes of shares and all that stuff. So the charter provisions here, as you see, lay out 3 alternatives for dividends, one of which, in alternative 2, is a cumulative dividend, which we talked about in the context of the 8%. We have the liquidation preference. I'm not going to get into this in detail because we've really already covered it, but alternative 1 is the non-participating preferred, just a regular old convertible preferred. And alternative 2 is a participating preferred. And then alternative 3 is a participating preferred which goes away at some level of return to the investors. The idea being if you get 5 times your money or 6 times your money or 10 times your money as an investor, you shouldn't have to get your money back too. And further your comment about what do I tell my clients, at a minimum I would say negotiate for a cap on the participation. So at some point if you deliver 3, 4, 5, whatever time return to the investor, their participation feature goes away. We had a question about voting rights and then about, vetoes over a sale. We're now getting into that neck of the woods. So voting rights here is pretty straightforward. It just says that the preferred stock will vote along with the common stock on, as we call it, an as-converted basis. So in computing our number of votes, back to our hypothetical, if the investor had 250,000 shares and the founders had 750,000 shares, and there was a common stock vote, the preferred would vote on an as-converted basis, and it would have 250,000 votes. Bless you. That's usually completely irrelevant. But that's the way voting on an as-converted basis works. So to get into this veto stuff, the next section that we have in the term sheet is protective provisions. And one of the things founder clients will often say is, you know, it's critically important that I own at least 51%, and you have to have control of my company. I can never give up control. I have to own at least 51%. And the truth is that in a typical venture capital deal, the founders will give up most of the meaningful control of the business just by taking money from a professional investor. Whether that investor owns 20% or 25% or 15% or 30%. Because the investment documents will say that most of what's really important regarding the company's future requires the approval of the investor. This shows up in two places in this term sheet, and I guess because of the way they organize this, we'll talk about it in two different places. But the first one is what's referred to as protective provisions. And these are things that require a vote of the investor securities. Voting is a separate class in order for the company to do something, irrespective of what the board might want and irrespective of what the common stock voting is on an as-converted basis might want. As you'll see, this includes a bunch of really important stuff. Liquidate, dissolve, or wind up, which is your sale veto, right? Amend the certificate of incorporation, which means that in order to authorize some new class of preferred stock so that you could raise more money, because it's going to be very difficult to sell common stock to an investor for all the reasons we've already discussed, you have to go get your existing investors' approval. Because in order to authorize more preferred stock under your certificate of incorporation, you've got to amend it. Then, you know, you will sometimes, as lawyers like to do, see situations where people are, you know, shot, stabbed, and poisoned. I also, in 3, can't authorize specific kinds of preferred without the investor's consent. If you look at number 5, I can't authorize the creation of a debt security, so I can't borrow. Right? So if you look at that package of stuff, you realize that the company is really relying on their investors to consent to any meaningful future financing transaction. So this is why I tell my founder clients, do your due diligence on your investors. Get to know them. Talk to other companies that they've invested in. Ask them for references. Talk to people about what their experiences have been. Are they good guys? Are they easy to deal with? Do you have a personal connection? Because you're really partnering. And whether you own 51% as a founder or 80% or 75% or any other percent you can come up with, you're giving up very, very meaningful control rights to your investment. We've talked a little bit about circumstances under which the preferred would convert. Optional conversion. The preferred stockholder at any point wants to convert to common, they can do it. I talked about my transaction I'm working on right now where some investors may be compelled to convert to common in order to get somebody to keep funding the company. If they do that, they're going to do it voluntarily, right? And sometimes, in order to prevent, if you have a large investor group, in order to prevent 1 or 2 recalcitrant investors from screwing up transaction that the bulk of the investors want to do, you'll see an ability to optional convert at some supermajority vote to prefer 2/3, 75%, something like that. We next had anti-dilution. And again, just to try to avoid getting buried, I'm going to give you a illustration of sort of the business point and then simple math illustration. Anti-dilution is intended to protect the investor to a degree against what we refer to in the business as a down round. And what a down round means is a new financing transaction where the pre-money valuation implicit in the financing is less than the post-money valuation of the prior transaction. And what that means is implicitly in all this math we've been assuming, the company's gone down in value. Right? Not a happy circumstance for anyone. So investors go, well, gee, you know, that's not very good for me. And if that happens, I was wrong about what the company was worth, but more importantly, you didn't deliver for me, founders. You didn't do what you promised me you were going to do. So I want some relief from that situation. So that relief is embedded here in this anti-dilution provision. And the math, as you can see from all the CPs and A's and B's and everything, is complicated. But it's relatively simple to understand if I give you this illustration. Let's say that I, as an investor, bought stock at $1. And my company now is going to go out and raise money at 90 cents. So that's a down round. And they're going to sell 10% of the company. So I got a 10% reduction in the valuation and 10% of the company being sold. The way that formula there on that page works is my conversion ratio, the price at which my preferred stock converts into common, will reduce from $1 to 99 cents. And what that means is that the total amount of common that I'll have the right to receive when I convert my preferred to common goes up by about 1%. So the relief is very, very incremental under Alternative 1. Alternative 2 is something called full ratchet, and it's hardly ever used. Used to be used on occasion, now completely not marketed in the sort of thing like a participation for security, where if you hear somebody saying, I want full ratchet anti-dilution, and you're working with a company, you should say that's not acceptable, and then push it, probably run for those. I'm just going to try to pick my spots here because I won't leave some time for questions at the end. So I'm not going to cover every sub-paragraph of this. I do want to talk a little bit about, on page 6, redemption rights. Most venture capital funds, if you're talking about somebody who's actually organized and raised and aggregated money in a fund, have a limited life. They are self-liquidating, so once an underlying investment liquidates, the money goes back to the investors, and ultimately, once all the companies are sold, the fund is done. And promoters of venture capital funds generally are given 10 years, subject to 1-year extensions, 3, maybe up to 5, to get all the money out the door, put more money in the companies in subsequent rounds of financing, need more money to grow, and have liquidity events with respect to all those companies. And we've learned over the last 10, 15 years that it can take a really long time to build value in a company that's just getting going in year 3 of a fund's life when the initial investment is made. So one of the things that investors will sometimes negotiate for is a redemption rate. And the business justification of that is, hey, my fund's getting a little long in the tooth. When I went out and raised all my money from my investors, I told them we'd be done in 10 years. It's year 9. I need you guys to get to a liquidity event. And a founder might respond with, well, I think things are going great. I think if you just give us another 5 years, we can deliver everything we said we were going to be able to deliver. So a redemption right is a way for investors to force founders of a business to get to a liquidity event. You will see them in different incarnations. The stereotypical California redemption right is here, which is basically my only right to get redeemed is to get my money back, plus if there happen to be any accruing dividend, to get my accruing dividend. And even if the business is worth a lot more than that, I can't force you to buy me out at fair market value. Sometimes in the Midwest, you'll see redemption rights that require the company to buy the investor out at the fair market value of the underlying security, taking advantage or taking into account its right to convert to common, any bells and whistles that the investor negotiated for with the preferred. The problem is the company has no money, right? Not necessarily by definition, but if it's a growth, early stage company, they've been spending more money than they've been bringing in, they're trying to grow the business, and the company's worth anything meaningful, they don't have the cash. So functionally, a redemption right is a way to force founders to sell the business because they can't come up with the money to redeem the stock. So the thing you should sort of take away from is you may find people requesting these redemption rights The devil really is in the details. How long before they engage? Is there a fair market value buyout, or is it just give me my money back? In the California give me my money back formulation is just basically a way of saying, look, this company's gone nowhere. I want to get it over with. I want to take my write-off from the take one, and I want to move on. So those are redemption rates. There's a provision, counsel and expenses. Believe it or not, the company will usually pay the lawyers on both sides. Not only their own lawyers, but also the investor lawyers. Sometimes subject to a cap on what the investor lawyer is going to get paid. So any of your clients who are raising money should go in with their eyes open on that. Then I mentioned that the term sheet maps to some underlying agreements that you can find at nbca.org. And the investor rights agreement is one of those. The first thing that's covered in the registration rights section, or the investor rights agreement, is registration rights. Registration rights in a nutshell are what happens if the company is in a position to go public or has gone public. So this is a high-class problem. And one of my clients likes to say that more money has been wasted negotiating registration rights than anything else in venture capital. Because if you can get to a point where the company's gone public, everyone should be pretty happy. So I want to only mention two things about registration rights that are takeaways for you. One is, if a company does go public, you should not assume that everybody can sell their shares the next day. And that's true for two reasons. Again, not turning this into a security seminar. But all of the founder shares, all of the investor shares, they have never been registered for public sale. The shares that are registered for public sale are the ones that the public buys. And on occasion, this happened in Grubhub, you'll see an opportunity for some investors and some founders to sell a few shares in the IPO. But that's the exception rather than the rule. In most circumstances, all the money's going into the company to help it grow, and the underwriters will tell you existing stockholders selling in the IPO is a bad market sign, doesn't show confidence in the company, we're not going to allow it. So all of your founders and your investors are sitting there with stock they can't sell. Because it's not registered under the securities laws, those shares, they're only going to be able to sell pursuant to Rule 144. And again, you're not going to turn this into a security seminar. That means that you're going to have to wait a minimum of 6 months. There may be some volume limitations if they're affiliates or insiders into the company. So you need to understand that you can't just assume that if you're working with founder investor clients, that the company goes public, they can sell their stock the next day. The other reason they can't sell their stock the next day is on page 8, under the heading of lockup. Underwriters are very concerned once a company goes public about making sure that the market for that company's stock is stable. Why? The underwriters just went out and sold their clients a bunch of shares of this company. And if the shares go down and then continue to go down, in part because a bunch of people are dumping in stock, it doesn't make the underwriters' clients very happy. So they will require, as this provision indicates, directors, officers, key officers, holders of significant amounts of the company's stock, often 1% or more, to sign what are referred to as lockup agreements. And the lockup agreement would typically last for 180 days, and it would say that none of these people can sell any of their shares without the underwriter's consent for the duration of the lockup. So even after you've gotten to that pot of gold at the end of the rainbow, you've got to wait probably 6 months before you can put any of the gold in your pocket. And with that, I'm going to leave registration rights behind. At top of page 9, we talk about management and information rights. Any of you who practice corporate law know that the actual statutory rights of the stockholder with information regarding the company in which they own shares are actually surprisingly limited. And professional investors, generally speaking, want to say, we're not going to bring any money to the table, but we're also bringing help. We'll make introductions for you. We're sage, we're wise. We'll help you make wise decisions about how you should be growing this business. Well, you can't help if you don't have information. So investors will generally negotiate for information rights regarding a business so that they know what's going on with their money. I want to use this, if you look at the second paragraph, the longer paragraph in this management information rights section, you'll see this bracketed word major. One of the concepts that we work with frequently is what constitutes a major investor. And this is one area we talk a lot about unalignment between investors and founders, at least potentially. This is one area where founders and large investors are generally aligned. Very frequently these days, you've got people who are investing relatively small amounts of money as part of a syndicate led by one or more professional investors or sophisticated angel types. So somebody's putting in $25,000, $50,000 alongside people who are investing $2 million, $5 million, whatever the number is. So from the perspective of both the big investors and the company, it's like, boy, I don't really want to give a lot of information to somebody who's investing $25,000 in a $5 million round. They don't want to be bothered by them. Management doesn't want to be bothered. The large investors don't want their entrepreneurs being distracted by people who are calling up every day saying, what's going on with my $25,000? So you will see in these documents concepts of certain rights, including the rights to information that are described here, will only go to major investors. So then when you're putting together a syndicate, you will often have a negotiation over what constitutes a major investor. Clearly the person who's putting in the most money, probably the person who's putting in the second most money. Well, what if it's my $5 million round and somebody's putting in $100,000? Are they a major investor? What if they're putting in $250,000? So you'll see negotiation and sometimes, again, unusual numbers and calibration over what constitutes a major investor so they can have these rights that go to major investors in here, information rights being one of them. The next concept that's in the term is described as the right to participate pro rata in future rounds, which I generally describe as a preemptive right. Some people refer to it as a right of first refusal, some people refer to it as a right of first offer. The concept here is that if I own 10% of the company on a fully limited basis, pretending all the options are exercised and everything else, and the company goes to do another round of financing, I should have the right to put in 10% of the round. The idea being, my cash is as green as anybody else's, and if I want to continue to own 10% of this business, so the company is doing it round at 3 times my original value, I should be able to preserve my pro rata ownership. So that's what this right to participate pro rata in future rounds is. And again, that's another right that often will be given only to major investors. The next thing, I alluded when we were talking about protective provisions earlier, that there was some stuff in the back of the term sheet that also dealt with investor approvals. Here, we have implicit in this provision, we'll get to it in a minute, the concept that the investors have a right to appoint at least one director. And here is a separate set of a list of things that require the approval of the director or some group of the directors, with the appropriate facts, that are appointed by the investor group. And again, it's another illustration of the fact that once you've taken outside capital, your ability to run the business, irrespective of what percentage you may own, is going to be constrained. Okay. We're at about 5:15. I'm going to blow through about 3 or 4 more things on this term sheet, so we're not out of time to talk about the Series C. Very important to investors that the key employees execute non-competition agreements. Can't have somebody leaving and competing with the business. So that's just standard operating procedure and not something that any founder is likely to successfully fight. Another key point is non-disclosure and development agreements. You will encounter, really to me, a surprising amount of frequency, founders of companies who say, well, I'm holding the IP personally. You know, the trademark, the patents, that's mine. I invented that. That's how I'm doing business. I'll license it. That is going to be unacceptable to any sophisticated investor. They're going to insist that all of the intellectual property be owned by the company and the company alone. Why? When they go to raise additional money, What if this person's gone off the reservation? What if they left under bad terms? You can't have a situation where there's clouds over the company's intellectual property if the intellectual property is important to its business and development. So that's something that you should expect if you're representing a founder of a business. I already alluded to the fact that investors are going to want the right to appoint, in all likelihood, at least one board member. One of the issues that you will see in the second little paragraph here, that two-line paragraph, how often does the board meet? Investors will say, I need frequent board meetings. I want to know what's going on. I can't help you if we're not meeting as a board frequently. Founders will go, you guys aren't paying. You're a distraction. I got to spend all my time preparing for board meetings instead of running the business. Leave me alone. So this will come in all sorts of different places. Monthly, quarterly, 6 times a year, 3 of which can be held by telephone. And you'll see a surprising nuance to the frequency of board meetings. Employee stock options, I think we pretty much already talked about what's really important regarding that. I'll just mention very briefly, options are generally going to subject to vesting, and a typical vesting schedule is set forth here, which is nothing for the first year, 25% of the total options after the first year, and then monthly increments thereafter with full 4 years. That would be a typical employee stock option vesting schedule. Right of first refusal and co-sale agreement, another separate agreement in the NBCA form documents, basically making sure that people can't just sell their shares willy-nilly, but that they're subject to a right of first refusal, easy for me to say, on the part of both the company and usually the investors. And then also what's referred to as a co-sale right, or take me along here, or tag along in some person's parlance, which just means that if a founder is selling stock and the investors say, hey, I'd like to take advantage of that liquidity opportunity, the investors can sell alongside the founder on a pro rata basis. Then the voting agreement is sort of the third major agreement in the NBCA documents besides the purchase agreement and the charter. And that has in brackets a drag-along provision. A drag-along provision can be a handy thing because if you get in a situation where a majority of both the founders and the investors want to sell the company, and you have some disaffected either investor or stockholders as part of a syndicate or founders, and they say, I won't participate in a stock sale, even though it's tax advantageous to the group, I'm just obstreperous and I'm going to hold my breath until I turn blue. A drag-along provision would permit some supermajority of the holders, either on a overall basis or on a class-by-class basis, to compel or recalcitrant minority stockholder to participate in the transaction, so long as everybody gets the same consideration on a per share and per class basis. 2 more things I want to mention on this term sheet, then I'll take a quick breath and then we'll move on to the Series C. Under other matters, we have founder stock. I've already described founder stock as sweat equity. And the question in sweat equity is how long you've been sweating and how hard have you sweat, and maybe more importantly, how much value have you built while you're sweating. And founders will say, boy, I've been working at this business for 2.5 years, and I got blood, sweat, and tears invested in my stock. And investors may go, that's fantastic, but if you were to leave tomorrow, I'd have a problem. Because I need you to be here pedaling the bicycle and continuing to sweat for the next 5 years to build value based on my money. And if you want my money, you're going to have to agree to put your sweat equity at risk. So this is, again, something that is heavily, heavily negotiated in the context of an investment transaction. And the facts will really make a difference. How long have the founders been working at? How much value have they built? How much more do they have to do? Again, typical vesting schedule, as we already alluded to, would be 4-year vesting, 25% after a year, monthly thereafter. But in the context of founders who've been working at something for 2.5 years and is just going out to raise their first round of capital, an investor is unlikely to be comfortable with that person leaving in 18 months and taking all of their equity with them. Because the time horizon for really building the value that the investor needs to get the kind of return they're expecting is much likely to be longer than 18 months. So then you will have negotiation over what we sometimes refer to as founder reinvesting. which is even if you founders agreed among yourselves to a 4-year vesting schedule when you formed the business, and often that's not the case, but let's pretend it is, we're just not comfortable economically giving you this money if you can leave and take all your equity with you in 18 months. So then you'll see negotiations. It's 31% vested and 69% will vest over the next 35 months, and you will see these numbers come out in really sort of non-intuitive ways. But what founders need to understand, and this is psychologically very, very difficult for them, because it's their baby, right? They've been working at it for a really long time. They've worked for no money. They've worked 80-hour weeks, for months on end. And now somebody's coming to them and saying, nah, you only own 25% of your stock. The remaining 75% is going to vest over the next 3 years. People have a real psychological reaction to that. But they have to recognize that it's a reality of taking money from professionals, relying on them relying on you, more importantly, to build value over the coming years. Finally, no shop confidentiality. The only binding provision that's in here in all likelihood. And professional investors, if they're negotiating a term sheet with a company, are going to want to know that the company's not just going to leave the next week if a better deal comes along. So they will negotiate for some exclusivity period to do their due diligence, work on the legal documents, and actually get the investment done. And you'll see those vary 45 days, 60 days, occasionally longer, but pretty typical stuff.
What's the consideration for that?
Interesting. I think you're going on nothing more than detrimental reliance, right? I'm going to spend time, money, and I'm going to pay Jerue, I'm going to do a bunch of other stuff. But no consideration of passive. Okay. That's it. That's all we have to say about that document. So that document's long, it's pretty complicated. When you go to look at all the agreements, you're going to see 100 pages of stuff, or thereabouts, maybe it's 80 pages. And these companies need to spend money on business, right? They need to not spend their money on lawyers. So these documents are fantastic if you're doing a $5 million financing round, or maybe even a $3 million financing round. But in these days, there's all this freeware out there, and companies can really get traction maybe if they raise $750,000 or $1 million. Are you going to pay 2 sets of lawyers a bunch of money to go hammer and tongs over 80 pages of agreements? So a lawyer out in California at a firm called Fenwick & West, about maybe 4 years ago, just took it upon himself to try to do something about it. And he created this website called seriesseed.com. And normally we connote rounds of financing by letters. The first one is the A round, the second round is the B round, the third round is the C round. And this guy said, well, I want to pick a term that's going to connote something that it's really like a very, very beginning. Like maybe before a really professional round. So he said, I'm going to call it Series C. So you will literally pick up a certificate of incorporation for a company, and it'll say that they're authorized to issue Series Seed preferred. So on this website, go ahead, I'm sorry.
She's passing on.
Anybody else?
No
problem. Give everybody a break and walk with you and me. So he literally did this sort of open public website where he created a much simplified form of purchase agreement. And as you have in front of you, maybe everybody now, a one-page, I'm going to screw this up here, a one-page term sheet for the negotiation of a simpler venture capital investment. So if we go through the Series C term sheet, one page, we'll see the stuff that at the end of the day, a sophisticated angel or an early stage professional investor might really view as important. So we've got the pricing stuff that we're used to seeing. When we get down to the fifth item, we've got liquidation preference, right? So they're buying preferred stock, even in the Series C document. Conversion rights, we talked about that. Voting rights. Again, we talked about how once you take money from an investor, you give up a lot of your rights to control your business. Look at the things that are on here. You can't, under item number 3, authorize a new series of preferred stock having rights senior to or on parity with this Series C preferred stock. functionally that means it's going to be extraordinarily difficult for you to raise any meaningful amount of capital without the consent of your Series C investor. Liquidate or dissolve, including any change of control. So there's your veto right on sale of the business. Documentation. The documents will be identical to the documents found at SeriesC.com. Now, my experience with the Series C term sheet when representing companies has been that very often investors will want to convey the message that they're user-friendly and they're easy to deal with, and they're going to present a Series C term sheet. My clients go, fantastic, let's sign it up. It's simple, straightforward, streamlined, I have to pay Jerue a lot less. And then the documents drafted by the investor show up, and they don't look exactly like the documents found at SeriesC.com. In fact, they got about 2.5 times the representations and warranties that the company is supposed to make in those documents in these Series C documents that the investor has prepared. So if you're ever working with these documents, that provision right there is really important, because if you're going to go through do something similar, it should really be simple. Financial information, we talked about reporting rights. There's still going to be standard information rights. Participation right, that's what I call a preemptive right, the right of first offer, so that people can preserve their ownership interest on a pro rata basis if they want to. Board of directors. There's going to be one, at least, representative of the Series C purchasers on the board so that they have input, information, etc. The other thing that's a little bit of a hook here is future rights, which purports to say that the Series C is going to get any bells and whistles that go along with the next series of preferred stock. When I'm an investor in representing companies, I'm very hostile to that provision because it's really open-ended, and who knows what those rights are going to be. I'm happy to negotiate with the Series C stockholders down the line, as will the new investors, but I don't want to negotiate on a cloud of this particular provision that purports to give them the same rights. Key holder matters. This is another variation of founder vesting, and maybe I'll use this to illustrate one more point. If you look at the second sentence there, it says full acceleration upon, quote, double trigger. What the heck does that mean, right? So if you have founders and there's a change of control transaction happening, so that they're now going to go to work for somebody, they may be concerned about what if they're not valuable to that person. Maybe they're just buying my company for the IP, they're not really buying it for me, I'm going to get fired. And by the way, a bunch of my stock is still subject to vesting. So I'm concerned about what happens to my unvested shares as a founder if my company is subject to a change of control. So over time, people have figured out this issue and have come up with a couple of different ways of dealing with it. The founder-friendly way is what we refer to as a single trigger. And what a single trigger would say is that if there is a change in control of my company, all of my unvested shares vest. The problem with that from an investor's perspective is this person may be really important. So if all their shares vest and the buyer needs them to stay around for a while, the buyer's going to go, well, this person now can walk away with all of their stock. And I need them to be here working for me as the new buyer. And I got to give them more equity incentives for them to stay. And that means that I'm diluting myself by giving this person more equity incentives. So you know what? I'm going to reduce the purchase price because I want to take the money I was otherwise going to give to you guys, the existing stockholders, and give it to this guy to induce him to stay around. So in order to avoid that scenario, you have what evolved into the double trigger, which means that accelerated vesting on change of control is only one condition. The second condition is that the person be fired without cause, or for those of you who work in the employment area, quit for good reason, demotion, and that sort of thing. And if those two things happen, then their shares will vest. But if a company wants them to stay around, their vesting will remain in place, so the buyer doesn't have to give them a reloaded economic incentive to induce them to stay. Okay, much shorter than those of you in the BCA background. How did they All right. So we got about a half hour. I could double back and cover a bunch of stuff, but I don't think we will. The next thing I've got here is a convertible note term. I think we'll spend most of the rest of our time talking about that and addressing any questions. So, convertible notes, as the name would imply, are a debt instrument rather than an equity instrument. And we'll walk through this, but convertible notes convert into equity if certain conditions are met. Convertible notes have come into much greater use in recent years than was the case when I first started working in the area. When I first started working in the area, they were almost unheard of. Then sometimes you do bridge notes where a company wasn't quite ready to do an additional equity financing for the existing investors who were willing to lend them a little money, in essence, to get them to the next financing. So that's where the bridge term came from, bridge to the next financing. And then gradually over time, people started thinking that these things were pretty good instruments for initial investments in an early stage company. Well, why did they come to think that? Well, as we've talked about from the very beginning of this presentation, one of the things that you have to do when you go to do an equity round of financing is you have to value the company, right? I need to know how much the company my equity that I'm buying represents. Well, if I hold a note and it's just a debt instrument and it converts into equity later, I would have to confront that right now. And in many cases, founders are incentivized to put off the valuation decision because they're going to say, gee, if I get some money in here and I can work on this thing for a year with some cash, I'm going to build a lot of value. And then when I go to do my equity round and take my dilution, I'm going to take a lot less dilution because everybody's going to see clearly that my company's worth a lot more than it was worth a year ago when I first actually got some money to work with. And investors are sometimes incentivized to put that off too. They'll say, I get it. I don't want to have a tough negotiation with you right now. I don't want to overvalue the company because if I go to do a down round down the road, it's bad optically for everybody, bad for the founders, bad for the investor. So let us give you some money on a note. Let's see what you can do with it. And then down the road, we'll value the business. The other reason I think people have come to like convertible notes is, on balance, the documents are a little easier. Depends on who's doing them, depends on how they approach them, but on balance, the documents tend to be simpler than equity documents. For instance, you don't have to draft a certificate of incorporation with preferred stock terms in it, because you don't have any yet. So that's why we're seeing increasing amounts of convertible note offerings, and probably the things I've worked on the last year, a lot of my practice is in seed and early stage. I would say I probably have done more convertible note deals than I've done equity deals. Or if not more, it's very, very common. So with that, let's walk through the GCLLC convertible note term sheet. The names have been changed to protect me and others. So let's start with type of security. So it's a convertible note. That means it converts into equity under certain conditions. It's a note. It earns an interest rate. The company has no money to pay interest, so the interest is going to accrue. And the expectation is that if and when the note converts, not only the principal balance of the note, but also the accrued interest is going to convert into equity. Offering size is pretty small. One of the recent phenomena of the marketplace has been seeing convertible note deals that are much larger than historically was the case. I worked on a $3 million convertible note offering in the fourth quarter of last year. I think that's the biggest one I ever worked on. That's just me. So you're seeing increasing amounts of money being raised in convertible note deals, but stereotypically, it's probably a six-figure number. Under offering size, minimum of $50,000 required for initial closing. Question in any one of these deals is, how do I, as an investor, make sure that my money is not the only money that goes in? So that the guy spends my money, can't raise any more, and I'm done because he didn't have enough money to execute on his business plan. So the question of how much money you're going to have to raise to have an initial closing is true in equity offerings, and it's true in debt offerings as well. A lot of the rest of this deals with that same concept. I'm only going to sell to accredited investors. I don't want to do a private placement memorandum. I don't want to take the securities risks associated with selling to non-accredited investors, so accredited investors only. You will usually see now at the bottom of the page in the use of funds, some at least provisions with moral suasion as to how the money is going to be spent. Sometimes you will see use of proceeds provisions actually appended to purchase agreements. That can be true in equity financings. It can be true in note financings as well. The bottom of this section raises what's always an interesting issue, which is, do the founders get paid? And this particular founder said, well, I'd like to have a $60,000 annual salary, but I acknowledge that I can't take all the money I might be raising and pay it to me in salary, and if I don't raise the amount of money I'd like to raise, then it really isn't appropriate for me to pay myself a salary. So unless, this particular founder said, unless I've got at least, I think, what is it, 3 months of runway, I'm not going to pay myself a salary. Sometimes you'll see people say, well, I'm going to just have my salary accrue, and it's going to be a liability on my financial statements. As soon as I get money from an investor, I'm going to take some of that money and pay myself my accrued salary. Probably not going to happen. The investor would like the money spent building the business as opposed to putting money in the founder's pocket, particularly for salary accrual. So I tell people when I'm representing who want to do that, I say, look, feel free, just don't expect to get it. Go to page 2. It's a debt instrument, so theoretically it's going to come due and the loan's going to have to get paid at some point. So that's our maturity date. The truth of the matter is the company is not going to have the money to pay the loan back when the loan matures. So the real expectation is that this thing is going to convert to equity or something else is going to happen. In most circumstances, the something else is going to be extending the due date of the note for a period of time. Keep at it, you're doing fine, I understand. I don't want to take this business over anyway by foreclosing on it, so I'll give you another year. Maybe I'll give you another year after that. In recognition of that reality, a lot of times now you're seeing these due dates getting pushed out. Historically, you might have seen 9 months, 12 months. That still happens from time to time, but much more likely to see 18 months, 24 months, which is just a recognition of reality. The other thing I want to emphasize in this particular section is there's a definition here of a majority in interest. And just like we talked about in the context of the drag-along transaction, where you'd like to have some mechanism that prevents a recalcitrant minority holder from blocking a transaction and creating trouble. In the context of a convertible note coming due, where most of the people who are note holders want to extend the notes, somebody who isn't cooperative really creates a problem, because they now have a debt instrument that's come due. And theoretically, they could sue to get paid back. So I always encourage my founder clients, and frankly my investor clients as well, to include in any note deal the concept of majority in interest or supermajority in interest. So if the holders of 2/3 of the principal amounts of the notes want to give the company another year to see if they can do what they hope to do, then you don't have a holder of a small note bringing the whole thing down. Interest rate. I had lunch with an investment banker today. He said, what's going on with convertible notes? Do they still earn interest? I said, yes. He said, what's the interest rate? I said, well, it's 8%, 6%, occasionally it's 5%. You might see outliers on the other end, but those are the things that you're most commonly going to see. So the bell curve clearly has the big bulge at 6 or 8%. And the idea is, again, not that it's going to be paid currently, but it's a way to give the note holder some little extra return for their very early risk, and also recognition that this thing is supposed to be a debt instrument, so they have some greater return on it. Prepayment. Amazing how often you'll see this. The notes can't be prepaid. because the ultimate goal of the investor is to convert this into equity and make a lot of money on their equity upside. So a company can walk in with a check and say, here's your money back plus 8%. The investor hasn't gotten their deal because they're taking this early risk with the expectation that the company's going to, double, triple, quadruple, whatever you want to pick in terms of the level of multiple. Sorry. The notes can't be prepaid. Unusual for those of you who work with kinds of notes, but the notes can't be prepaid. Seldom, if ever, a security interest. Now we get to the stuff that maybe is a little more interesting, which is, great, I'm doing this to convert it into equity. When does that happen, and how does that happen? So let's talk about the typical way a convertible note converts into equity. The typical way is an expectation that the company's actually going to go out and do this equity offering that we've been putting off. From an investor's perspective, before they are forced out of their note position and converted to equity, the valuation that, as we'll talk about, is driven by somebody else, they like to know that it's a legitimate equity offering. What do we mean by that? Well, legitimate in terms of its size, so that it really gives the company a meaningful amount of runway. Legitimate potentially in terms of who's investing the money. On occasion you'll see a provision that says it has to come from professional investors or recognized venture capitalists or angel investors reasonably acceptable to the note holders or words like that. And it's not your uncle, it's not your brother, it's somebody who's really an arm's length person. So meaningful amount of money from a legitimate investor. In this particular term sheet, the meaningful amount of money was $1.5 million. These days, you'll often see that number lower. You'll be surprised to see it at $1 million. Sometimes, depending on the nature of the business and the nature of the amount of money that's being raised, it might be higher. But something that conveys to the investor that it's a real deal. Then, what happens if a financing that's a qualified financing, forcing conversion of the notes? The note holder goes, well, wait a minute. I'm getting a price that's determined by this person who's coming in now after my money has been used to ameliorate all of this risk. That's not fair. I'm not 8% accruing interest in converting into these securities is not sufficient compensation for the risk I took when I wrote the first check. So the way that gets handled is by giving the investor a break on the conversion price. In this term sheet, the break, which we refer to as a discount, is in that 80% number. You see that in the middle of the paragraph. So what that means is that if the investors in this legitimate qualified financing round that are forcing the note holders to convert their securities, or their notes into equity securities, are buying stock at $1 a share, the note holders will buy that same stock at 80 cents a share. So they get a 20% discount on the price to compensate them for that early risk that they took when they wrote the first check. So their interest will convert, so that's a little goose on the return, and then they'll get a 20% discount. There is also embedded in here this concept of a cap. What the heck is that? Further, this concept of compensating the note holders for their early risk, they will say, look, if you build a ton of value, if you take my few $100,000 and you build a business that's worth $20 million on the basis of that money, you did a great job, but I did a great job too. And a 20% discount in converting my interest is not enough compensation for me in that sort of home run type situation. So you will see investors and company founders negotiate a cap. And what the cap is the maximum value implicit in the conversion for the note holder. This particular transaction has a cap of $3,250,000. So let's hypothesize that the pre-money valuation implicit in the new financing round that's going to force conversion is $6.5 million. What that means is that instead of the 20% discount, because of this $3.25 million cap, the note holders are going to convert at a 50% discount, half of the $6.5 million that I've posited. So the cap is a way to compensate the note holders for taking that early investment risk when the founder builds a lot of value on the basis of the money that they raised in the note. You get the cap done correctly, you get the cap or the discount, but you don't get both. So that's the auto convert, and that's sort of everybody's expectation as to what's going to happen. Voluntary conversion prior to qualified financing would basically mean if the company goes out and does some smaller equity round, but the note holders say, you know what, I like the price, I like the terms, you know, you said you had to raise $1.5 million, but you're raising $1 million and I'm comfortable if that makes you viable, I have the option to convert into that financing. This particular term sheet does not give the investor the benefit of the discount under that scenario. The idea being, hey, it's voluntary. If you don't want to convert, if you want to wait around for qualified financing, convert at your discount, feel free, but you don't have to. One of the issues with that is it's unlikely you're going to be able to raise an equity financing if you have debt on the books. So in that circumstance, when you don't have a forced conversion, you're probably going to have a negotiation between the note holders and the equity investors in terms of how and when and under what circumstances the convertible notes are going to convert so that the equity investor will actually put the money in. So we already described our scenario of what happens if the notes just come due. Investors want to just take over the business, doesn't want to shut it down, doesn't want to accept payment in all likelihood. So as these deals have evolved, we've evolved into a voluntary conversion at the maturity date, which would permit the investor to get the benefit of equity upside at maturity, not just have to take the money back plus 30% interest. And we've said here that voluntary conversion is at the cap. This is a fallback, if you will. All of these things can be subject to negotiation at the time, but if a company builds a lot of value, never does a financing, never has to do one, this is a way to compensate the note holder investor for their risk by letting them convert at maturity with the cap. Further to my comments about make sure that you can't have a recalcitrant note holder create problems for you, there's a voluntary conversion provision that basically says on any terms and conditions that the majority of the note holders in the company would agree to. Then you have the question, for all I've said about the notes are never prepayable, what if the company gets sold while the notes are still outstanding? Again, the investor doesn't just want their money back plus an 8% return, and there hasn't been any financing transaction to permit the investors to convert into equity. And this could be happening at a very high valuation if the company founders have done well. So here you have a provision that in essence says, I can get my money back, doubled, plus my interest, if there's a company change control transaction that happens during the pendency of the note. Often, these days, you will also see a provision that sort of binds together with this voluntary conversion of maturity date and says you'll also have an option to convert to the cap. So if a company has builds a $30 million value and the note would convert into 20% of the company, the note holders can convert into that 20% of the company at the cap value and realize some level of equity return on their debt. And if they don't like that, they'll at least have an opportunity to get double their money. Company structure, I want to use this as a way to mention something. It is highly unusual for me to work on a transaction that doesn't involve a Delaware C corporation. I just did one recently that involved an Illinois benefit corporation. That was the first time I'd ever done that. On occasion, I've done Illinois corporations. On rare occasion, corporations from some other state. But the market clearly expects that people are going to be Delaware corporations when they accept sophisticated money. This particular situation was a guy who was an Illinois LLC, didn't want to change, go through the time and expense to change at this particular point in time, but recognizing that that's what sophisticated investors would likely require, he put a provision in his term sheet saying, when we get to that, I will convert to a Delaware C. Information rights. Some things roughly comparable to information rights in an equity deal, just so homeowners know what's going on with their money. Very often, those will be omitted in a note deal, but they were here. Protective provisions, again, often omitted in a note deal, but they are here. Two more provisions I want to mention, and then I think we've got a little time for questions if you have any we haven't covered. Co-investment rights. We talked about preemptive rights in another context so that I can preserve my economic ownership on a percentage basis. Well, if I have a convertible note, I don't really have an ownership percentage. So if the company's going out to do its equity financing and I like the deal and I'd like to invest, I don't have any contractual right to do so. So how do I deal with that? In this particular transaction, it's dealt with by saying that if you gave me at least $25,000, a little bit of an incentive to people to invest at least $25,000, then you will have the opportunity to match that amount, that amount of equity investment in the next financing round. So not only will you get your note conversion, not only will you get your discount, not only will your interest convert, but if you like the deal, you can also double down, if you will, and invest an equivalent amount of money in the equity. Fees and expenses, everybody's paying their own in this deal. Doesn't always happen, but that's what was here. And confidentiality provision, and that's the only binding provision here. This wasn't a no-shop situation. This was more a company-prepared document that we were taking out to the world, say, if I bring you definitive documents embodying these terms and conditions, will you invest in my convertible note? So I always encourage my clients who are looking to raise money to do it on the basis of a term sheet first. That way, they can go out to their prospective investors, show them the terms before they've paid with the draft documents. They can go to these prospective investors and say, before I turn Jerue on and have to pay the exorbitant fees, will you do this deal if I bring these documents to you? So you can have the negotiation of the economic terms in the context of a term sheet, rather than having that negotiation in the context of definitive documents where it's harder to change and more expensive to change. With that, I'll open it up to any other further questions. I really thank you all. You've been extraordinarily attentive and very patient with me walking around and turning around and turning my back to you and all that. So I really appreciate the opportunity to do it.